Good afternoon, everyone, and welcome to another episode of Silicon Giving 2021 Employment Law Forum webinar series entitled Termination of Employees in the Context of the COVID-19 Pandemic. My name is Nữ Nguyen, and I will be the moderator this afternoon. It's now my privilege to introduce our distinguished speaker today, Ms. Sarah Galaski, who will provide us with legal grounds under Vietnamese law for termination of employees along with the relevant and practical case studies. Ms. Sarah Galaski holds the position of counsel at Silicon Gibbons and is a member of the firm's corporate and commercial team, focusing on labor and employment law, as well as compliance and dispute resolution work. Sarah has over 13 years of professional experience in legal service and has been based in Vietnam since 2013. During this time, she has worked for large international firms and represented multinational companies in the industry, pharmaceutical, luxury brands, and textile industry. Sarah has advised a full range of employment matters, such as investigating sexual harassment claims and drafting employment contracts, internal labor regulation, service agreements, and consultancy agreements. She also has experience advising on employment issues in relation to the global assets and share transactions. Sarah has been actively involved in Eurojam in Vietnam, acting first as the co-chair of the Human Resources and Training Sector Committee, and then a member of Eurojam Executive Committee. In these roles, she has consulted on labor issues with the International Labour Organization, UN Women, and European Parliament. Sarah is also the co-founder of the Women in Business Sector Committee at Eurojam. Prior to joining the firm, Sarah acted as a litigator in Canada for a large international firm where her cases involve issues ranging from corporate fraud to employment matters. Our presentation today will last for about 1 hour. And with that, I now will turn it over to Ms. Sarah Galaski.
Okay, thank you very much, New. Hello, so today our topic is about the termination of employees in the context of the COVID-19 pandemic. So with the COVID-19 pandemic, there are a lot of considerations in respect to how to carry out a termination, and we have to deal with a lot of special circumstances. So our agenda today, we'll first discuss probation, mutual termination. We'll go over the various grounds of unilateral termination by the employer. We'll talk about protected employees, employee resignations, employee entitlements upon termination, and the consequences of illegal termination. So starting with probation. Probation is something employers should be very aware of and be thinking about when they enter into a contract with an employee. As you'll learn through the rest of this presentation, it is very, very hard to unilaterally terminate an employee in Vietnam. So when you first hire someone, you have a chance to put them on probation. For most types of positions, the maximum period is 60 days, but for executive types of positions, it's 180 days. And during that time, you can assess their performance. So this is kind of the one case where you can terminate an employee without notice or compensation. Under the previous labor code, probation had to be addressed through a separate agreement, separate from the labor contract. But the new labor code says it can be included within the labor contract itself, which is a lot more convenient. Employees can only be subject to one probationary period. I've had a lot of inquiries where employers say, well, we're not so sure about the employee. What if they agree to an additional probation period? But that is not allowed. The parties can't mutually agree to another one. If you change the employee's position within the company, that is not a basis for another probation period. There's only one. During the probation period, you can pay the employee slightly less than their official salary once they've completed probation. 15% lower. And at the end of the probation period, the employer must inform the employee of the probationary results. And If both parties are satisfied, they either continue the relationship under the labor contract, or if they have done the probation through a separate probationary agreement, they need to enter into a labor contract. So as I mentioned, the probation period is typically not very long. So if the individual is an enterprise executive, as defined by the law on enterprises, so this means basically the general director of the company, deputy general director, and also positions that are identified as managers within the charter of the company. So that would typically include the chief accountant. So these very important positions under the new labor code, now you have more latitude. You have 180 days. So I think a lot of companies are kind of relieved from that. This is new under the new labor code. Job positions requiring a junior college degree or above have a 60-day probation period. Those requiring basically vocational education is 30 days, and all other jobs is only 6 working days. Now we're moving on to mutual termination. And so if the probation period has passed, this is really your next best alternative of how to terminate an employee if things are not going well. So it's very difficult to unilaterally terminate employees in Vietnam. As we will learn throughout this presentation, unilaterally terminating an employee requires the employer to have certain policy documents in place before the issues occur. And generally, there are very lengthy termination procedures that have to be followed. But you can bypass that if you convince the employee to enter into a mutual termination agreement. These can be entered at any time under any circumstance. So even if the employee is a protected employee, and we'll discuss those types of employees later, they can still enter into a mutual termination agreement. Generally, employees demand a settlement payment to agree to this. Otherwise, they don't have much motivation to agree to terminate their employment. There are some key contents that should be included in these agreements. First, you have to state that the grounds of termination are mutual termination, and you should quote the provision from the Labor Code, which is Article 34.3. The termination date of employment has to be very clear. You should include a detailed list of the employee's termination entitlements. So it's usually an appendix to the agreement. You need a release and waiver from the employee in favor of the employer and related parties. And you should also mention any other obligations on part of the departing employee. So this is usually a non-disparagement clause or non-disclosure clause. A lot of employers want the terms of their mutual agreement or mutual termination agreements to remain confidential. One concern is if all the other employees learn that this departing employee got a big settlement package, maybe they will go for the same thing. So in the context of the pandemic, signing a mutual termination agreement with an employee can be more difficult. In some cases, foreign employees have gone back home during the lockdown in Ho Chi Minh. So you may have problems getting wet signatures on the documents. One solution to this is you can request the employee to sign an agreement and take a photo, and then provide a scanned version, and then follow up with the original version with wet signatures as soon as possible. Another complication could be if the employee, let's say they went overseas and they have valuable equipment of the employer that needs to be returned. So one solution is you could withhold maybe part of the settlement payment upon the return of the equipment. It would have to be the ex gratia portion of the payment. The statutory payments would have to be paid within 14 working days. But if you have an ex gratia portion, you could make it contingent upon the return of that valuable property. All right, so moving on to our next section is unilateral termination by employer. So a lot of jurisdictions basically only require employers to provide notice, and they can terminate at will. So for example, in the US, that's generally the structure. Employers simply have to provide notice, and for any reason, they can get rid of their employee. This does not apply in Vietnam at all. It's very difficult to terminate employees. You have to have a recognized legal ground. These are the most common here: poor performance, the employee providing untruthful information during recruitment, if the employee has been absent from work for at least 5 consecutive days without a legitimate reason, redundancy, what I call force majeure terminations, and they're very relevant right now because it lists a number of natural disasters, and one of them is the pandemic. So that could form a basis to terminate employee. And then dismissal. And in Vietnam, dismissal means dismissal for misconduct. It's a disciplinary measure. So we'll start with poor performance terminations. So these types of terminations are not simple. The definition under the Labor Code states that if the employee repeatedly fails to perform the work according to the criteria for assessment of the employee's fulfillment of duties. So first of all, it's important to have a detailed job description as part of the labor contract, because exactly what's expected of the employee has to be clear. In addition to that, the employer needs to have in place criteria for assessment of the employee's fulfillment of duties, or as otherwise is often referred to as a performance management policy. So this has to be in place before the poor performance occurs. If you're unhappy with an employee, you can't put it in place later. It has to be consulted upon with the corporate level trade union if your company has one. So this big change under the new labor code is that this consultation step is only required if you actually have a corporate level trade union. In the past, if you didn't have a corporate level trade union, you would have to deal with the immediate upper level trade union, which would typically be the district level, like the neighborhood trade union, or the industrial zone trade union. But now the new labor code says that step's not required. Another requirement under the new labor code is for the employer to have a dialogue in the workplace session. So in this case, the corporate level trade union would participate if it exists. And then 3 people from the employer side would participate together with 3 to 23 people from the employee side, depending on how many employees are at the enterprise. And the trade union would work together with the employer to help the employees choose these representatives. Basically, they would have like a small election to choose who would represent the employees in this process. Carrying out the dialogue in the workplace would follow the employer's democracy in the workplace regulations. So this is a separate policy, and it sets out how these discussions take place, the logistics. It's a somewhat new requirement. It came into effect beginning of 2019, but very few employers actually have this in place or follow it. The other consideration is you also have to show that the employee has repeatedly failed to perform their tasks. So in practice, what this generally means in Vietnam is that the performance management policy will set out an evaluation period. It's usually annual or biannual. If the employee receives an unsatisfactory rating, then he or she would receive a warning letter and be placed on a performance improvement plan or policy. The PIP will set out specific objectives for the employee to meet within a certain time period. And typically in Vietnam, it's usually about 3 months. Then there's another evaluation after the PIP. If the employee meets the goals, they are released from the counseling process. If the employee does not meet the goals, then the employer may undertake the dialogue in the workplace session and issue the notice of termination. So for poor performance, employees are entitled to notice. If these notice periods generally apply for unilateral termination with a few exceptions, so you'll see that as we go through things. So an indefinite term contract, it's 45 calendar days. If it's a contract of 1 year to 3 years, 30 days, and a definite term contract under 1 year, it's only 3 working days. And employees would also be entitled to severance for this type of termination. So in the context of the COVID pandemic, poor performance terminations are a lot more difficult than they used to be in the past. It's difficult to assess employees' performance while they work remotely. You can't necessarily tell the hours they're working. It's harder to monitor what they're actually doing. So it's important to have key performance indicators or KPIs that are easily measurable. So this could be a certain volume of sales or a number of billable hours worked per month, like in the case of us lawyers, something objective and measurable. However, because of the pandemic, employees could argue that their failure to meet these targets really is not a matter of poor performance, it's due to the pandemic. So I could see legal problems arising if you, let's say you try to terminate an employee under the grounds of poor performance because they failed to meet their sales volumes, but maybe that was really due to the fact there was almost a complete lockdown for several months in Ho Chi Minh City. The other big challenge with this is that the employee evaluations and the dialogue in the workplace session may have to be conducted online, depending on your company policies and the spread of COVID. So in that case, if these processes have to be done online, then afterwards, the employer should circulate written minutes in hard copy and obtain wet signatures. Vietnam wet signatures are very important. The government really wants to see hard copies of documents with wet signatures. So this brings us to our first case study. So for the case study, I'll go through the scenario, and then if you can type your comments into the Q&A box, then New will help deal with those comments. And then afterwards, I'll give you the answer, if you will. So in this situation, you have an employee, Min, who has an indefinite term labor contract, who was rated unsatisfactory at his annual performance evaluation. Your company wants to terminate his employment as soon as possible. You have a performance management policy, which has been consulted upon with the trade union, and it follows our recommendations. What is the minimum amount of time required to terminate this employee from the time of his performance evaluation?
Okay, my attendees, please give your answer into the Q&A box. Yes, can you give an estimation on how long it will take for termination based on this basic? 3 months, 3.5, or 5 months? 3 months, 45 days. Yeah.
So consider all the steps that are required. So you're at the stage where he's just failed.
Yes, many attendees give the answer, the same answer. That's 45 days. Okay, so Sarah.
Okay, I'll go to the answer. It would take about 5.5 months. So it takes a really long time to terminate an employee for poor performance. So after his first negative performance review, he has to have an opportunity to improve his performance, because keep in mind, you have to show this person has repeatedly failed to meet expectations. So We recommend about a 3-month period. So there's 3. The dialogue in the workplace session is not very simple. You have to basically work with the corporate level trade union to elect representatives of the employee to discuss the process with you. In practice, takes about 1 month. And then after that's complete, he gets 45 calendar days notice. So that adds up to 5.5 months. So it's important to see that poor performance terminations are really not easy. So keeping that in mind, what other approaches available? Does anyone want to put forward some ideas?
Yes, I can see that someone suggests that we can
Mutual-
have a mutual termination.
Yes, correct. That is your other option. So you'll see in Vietnam that you often have to fall back on mutual termination, because if you consider this scenario, if you just look at the cost even of keeping this poorly performing employee on another 5.5 months, then just the legal costs involved in dealing with the dialogue and the workplace step. So it really would make more sense to sit down with him, say, look, your performance is really poor, and offer the costs you would be spending for maybe his salary for that 5.5 months, and for your legal costs, offer it as a settlement payment instead. Okay, moving on. The employee provided untruthful information at the recruitment stage, another ground.
Okay, Sarah, yes, we have one question relating to the case study.
Yeah.
Yes, so the question is, who should join the dialogue for this case?
Okay, so it would be the representatives of the employer, so 3 people, then the corporate level trade union, and then representatives of the employees who are not members of the trade union, and 3 to 23 of these people, depending on the size of the enterprise. So for the representatives of the employees who are not trade union members, then you have to do like a small election process. So it's not very simple. Okay, so moving to the next round. Okay, so providing untruthful information during recruitment. This is a new ground of termination.
Sorry, yes, but I'm sorry because
more questions.
There's follow-up questions. So 3 people of employers is a must for the dialogue.
Sorry, is it a must? In practice, it's uncertain whether it will actually be enforced. So in practice, what we're seeing is a lot of employers are not following this step. Okay. But the labor code only came into effect January 1st of this year. So it's sort of uncertain exactly what the court and authorities will expect. So right now it looks like this may not be heavily enforced, but if you wanted to be really, really careful, you could follow that step. All right. Okay. So untruthful information at the recruitment stage. So this is a new ground. It only came into effect beginning of this year. In the past, if an employee had lied to you at the recruitment stage, practically speaking, the most you could probably do would be to discipline them, but actually terminating the employment relationship would be very hard. So this is a good development from the employer perspective. Basically, if the employee gives untruthful information about the following issues, so their educational level, occupational skills and qualifications, health conditions, or if there's something else that the employer can show directly affects the performance of the labor contract, then they can rely on this ground of termination. So in this case, employees are still entitled to notice, and it's the same notice period that would apply for poor performance. So 45 days for an indefinite term contract, 30 days for a contract of 1 to 3 years, and 3 working days for other types. And severance allowance also applies in this case. The employee is absent for at least 5 consecutive days. So this is also a new ground of termination, and it's a very good development from the employer perspective. The employer is permitted to unilaterally terminate a contract if the employee is absent for at least 5 consecutive days within a month without proper reasons. And proper reasons mean natural disasters, fire, the employee or a family member is suffering from an illness, which can be backed up with a certificate from a health facility, or other reasons that might be in the employer's internal labor regulations. Those are the working rules of the employer. So this was a good development from the employer side, because in the past, you had to go through the whole dismissal process if the employee was missing from work for 5 days. And in practice, it would be very hard because you had to serve the notice of the disciplinary hearing. And in some cases, the employee would have just disappeared. And so it would take quite a long time to deal with the disciplinary hearing aspect if the employee couldn't respond to the notice. But now it's pretty simple. You just have to show they've been gone 5 consecutive days. There's no evidence of any proper reason. And in this case, there's no advance notice and no severance. So it's very simple. So in the context of COVID-19, it's actually a little bit more complicated. So a lot of businesses are still having their employees work remotely from home. So in this case, it can be challenging to show that the employee is absent from work. You would have to have some evidence that the employee was unreachable by phone, that they weren't responding to their email, or they weren't logging into the company's computer system. So you would need like additional evidence. If someone doesn't come into the office for 5 days, it's pretty clear cut, but now it's a bit more complicated. Another complication is that the pandemic could be considered a natural disaster. So if the employee says, oh, I can't come to the office for pandemic-related reasons, that could be considered a proper reason. So just to sum it up, relying on this ground is not very simple if the employees are still working from home. Okay, now we'll move on to redundancy terminations. So in the course of the COVID-19 pandemic, we have seen a lot more of these redundancy terminations. Again, in Vietnam, these are not simple. You need to have a legal basis for the redundancy, which is limited. It can be either change in organizational structure, technology, or products. It can mean economic reasons, which would include an economic crisis or depression, or changes in the law, or state policies restructuring the economy, or international commitments. Or it can include the separation, division, consolidation, merger of enterprises, or asset transfer. In these cases, employees are entitled for job loss allowance for working periods not covered by unemployment insurance. And later I'll go into more detail about employee entitlements such as this. So to carry out a redundancy termination, the most common ground that is relied upon in Vietnam is organizational restructuring. So these steps focus on that ground, that legal ground for the redundancy. So basically the company's investor, it could also be the local company's members council, possibly. They need to issue a resolution or a decision for reorganization. Then if it's coming from the investor level, the company then needs to issue its own resolution for reorganizing the Vietnamese entity. And the company needs to form a labor usage plan, consulting with the corporate level trade union, if one exists. And the labor usage plan basically sets out the legal grounds for the redundancy, the entitlement or its attempts to retrain employees, and the entitlements that employees will be paid upon their termination. This redundancy is also subject to the dialogue in the workplace session. So as I mentioned for the poor performance, it's sort of uncertain whether this aspect of the labor code will actually be enforced actively by the court or authorities, but the new labor code does include this step. Then the company needs to notify the employee and the Provincial People's Council at least 30 days in advance. And then the company needs to issue a decision on termination of the labor contract. So this can be done together with step 5. The decision on the termination could be included in the notice provided to the employee. And then the employee needs to pay job loss allowance and settle the entitlements to the employee. So in the case of redundancy due to reorganization, the employer has up to 30 days, 30 calendar days to pay termination entitlements. So some special considerations in the context of COVID-19. So completing all these required steps is really time consuming. So you need to basically budget several weeks to prepare the supporting documentation, a month to complete all the consultation obligations. Consultations may need to be completed online. Employers should circulate minutes of meetings with the relevant parties and obtain wet signatures again of the discussion. And we're seeing a lot of labor disputes arising from redundancy termination these days. Seems that employees are more willing to dispute their termination because they're worried about finding a new job in this environment. So we recommend, even after you commence the redundancy procedure, to try to negotiate mutual termination. You can actually even include this in your labor usage plan as a step you're taking to try to offer the employees a more beneficial settlement package than required under the law for mutual termination. So we're at our next case study. So in this case study, your company, ABC Limited, wishes to terminate one employee on the basis of redundancy. What positions do you think cannot be made redundant? And what are some concerns with this approach?
Okay, the attendees, this is your turn. Please give your answer into the Q&A box so that we can see how you think that is the position that cannot be made redundant. Like any manager, managing position that you think that cannot be made redundant? If there's any position coming to your mind, like managing director. Okay, then how about the chief officer, chief executive officer, the chief financial officer, HR manager, and attendees has an answer that it should be HR manager. So
okay.
Sarah,
okay,
answer, yeah.
And then also, what are some concerns with this approach with only making one person redundant? Any other comments in respect to that?
Yes, it seems that is a very difficult question.
Okay.
So,
go ahead.
Yes.
Okay, so so really, if this person is the chief accountant or general director, they cannot be made redundant. Every company requires these two positions as a basic thing. With the HR manager, from a practical perspective, it could be hard to justify, but I have seen cases where companies will basically outsource their HR function. Often what they'll do is they have a related company also within Vietnam, and that related company will provide HR services through a service contract to the main company. So technically speaking, it is still possible to make the HR manager redundant. But the chief accountant and the general director are legally required positions, so it's impossible to make them redundant, basically.
Yes, so how about union leader? Some say
Oh,
that
okay.
union
I'll get to that
leader.
later. That will be covered in our section on protected employees. Because yes, it is complicated to terminate trade union members of the executive committee of the trade union. So I will get to that later in the presentation. But it's not impossible, but it's very hard. Okay, so under the law, it's not strictly required to form a labor usage plan where one employee is made redundant. But there are some court cases where the judge has said this step should have been followed, even though it was only one employee. So it may be from a very prudent approach to follow that step, even if it's only one person. However, if the judge did make that ruling, you could probably dispute it. In general, you should be aware that the court views redundancies with only one employee being retrenched very suspiciously. There are even some court cases where the judges say this is not even technically possible. So if it's only one person, the best approach is to really push for mutual termination. Again, but it is very risky to just make one person redundant. Okay. So moving on to force majeure terminations. Okay. So specifically, an employer may unilaterally terminate employees if there's a natural disaster, a fire, a pandemic, or relocation or downsizing as requested by a competent authority. And the employer has already exhausted all other possibilities. So what makes it tricky right now is this ground of termination is not relied upon often in Vietnam. So the meaning of already exhausted all other possibilities is not clear. So from a prudent approach, it seems that the employer should be able to demonstrate that it has tried some other measures to try to avoid terminating the employees. So this could be temporarily suspending operations, requesting employees to take unpaid leave, something like that. So if you just basically say, well, business is slow due to the pandemic, I'm going to unilaterally terminate several employees, that would be probably pretty easily challengeable. So notice periods also apply in the context of these terminations, the standard ones I discussed before. Severance allowance also applies if the necessary conditions are met. And just in general, it's a very untested ground of termination, so it's risky. But on the other hand, it's much more efficient to rely on this ground instead of redundancy, for example, because it's fairly straightforward. So if your business has tried other measures like temporarily suspending operations and trying to have employees take unpaid leave, and the company can show there's just not the funds in the bank account to pay the employees, probably could rely on this ground. Okay, here's our next case study. Okay, a foreign employee, Thibault, decides to go home during the lockdown in Ho Chi Minh without receiving permission from his employer. The lockdown lifts in Ho Chi Minh, but Thibault does not have an entry permit, so cannot get back into Vietnam. Just as a bit of context, it's very hard to enter Vietnam right now. If you're a foreign worker with a work permit, you have to have an entry permit in place to come back to the country. Typically, these take like 4 to 6 weeks to obtain, and you have to have a quarantine plan, meaning you have a quarantine hotel lined up that you have to stay in for 8 nights. Yeah, so it can be very difficult to re-enter Vietnam, especially if you left before you got your entry permit. A lot of the best practice is to get your entry permit before you leave Vietnam to make sure you can get back in. Anyway, so Thibault's employer requests all employees to return to the workplace, but Thibault is in France. Does Thibault's employer have a basis to terminate his employment? Would your answer change if Thibault had received permission?
So what's your answers, attendees? Do you have any answers whether Thibault is have the basic to be terminated his employment? Yeah, some say yes and some no.
Does anyone want to venture what that legal basis could be?
So if he received permission but didn't return to work, then yes, the employer can terminate. Yes,
Oh, if he did
yes.
receive. And under what ground? Does anyone have any ideas?
Do you know the ground? No one.
No one wants to venture.
Yes, no one have the.
Okay.
Yes, one say that 5 days not attending to work with a reasonable reason.
Right.
And,
yes, that could possibly be relied on. Yep.
Yes, definitely. Another attendee say that yes, if there is the agreement between the employer and the employee on this permission, otherwise the answer is no. If there is the agreement between the employer and employee on this permission, so it means that the employer and the employee must agree in advance about the permission.
Okay, I'll go through my answer now.
Yeah.
Okay, so since he went home without permission, the employer may be able to terminate him on the basis of being absent for work from the workplace for 5 days or more, maybe. But let's say hypothetically, he can perform all his work duties remotely. I don't think they could really rely on that ground. That ground might be more relevant if his physical presence in Vietnam was required. If he had permission from his employer to go home, he really couldn't be terminated based on his absence for work, because that's kind of like a proper reason. The employer gave permission for him to go and kind of assumed part of that risk. Another possible ground of termination could be a force majeure termination. So let's say there's some problem with, let's say, his work permit, and for some reason he can't get an entry permit to come back to Vietnam within a reasonable space of time. So if the employer could show it made like every reasonable effort to help him re-enter Vietnam, but it was impossible, then the employer may be able to terminate him under that ground of force majeure. Any other comments or questions? Or can I move on?
Yes, it seems that no one have any comments on this topic, right? Okay.
Okay. Okay, the next one is dismissal. All right, so dismissal is only permitted in very limited circumstances. And in order to dismiss someone, the misconduct has to either be stated in the internal labor regulations. These are the registered working rules of the employer, the labor contract, or the labor law. When it says the labor law, it would mean the labor code. And the labor code lists out a number of grounds of misconduct where dismissal is permitted, and I'll go through those in a moment. But if misconduct is not specifically mentioned in the ILRs, I think it would be risky to try to rely on the labor contract or the labor law as a basis to dismiss someone. It's because this provision is brand new and it's kind of uncertain how it will actually be applied in practice. So when the employees are dismissed, they are not entitled to severance allowance or notice. However, in practice, the employees do get notice because there has to be a disciplinary hearing first. And that takes some time. So it's not as though someone commits an act of misconduct and you can push them out the door. You still have to go through a number of procedural steps. Okay, so the following constitute a legal basis for dismissal. So the labor code lists out several acts of misconduct that are listed here. So these include theft, embezzlement, gambling, assault, use of drugs at the workplace, disclosure of trade or technology secrets, infringement of the employer's IP, and sexual harassment. So in these cases, the employer does not have to demonstrate the misconduct caused any monetary damage. There's another category of acts for which an employee may be dismissed. And these are acts that cause or threaten to cause serious damage to the assets or interests of the employer. So in the case of these types of acts, the act of misconduct, first of all, has to be specified in the ILRs. And the ILRs also have to set a level of monetary damage, a monetary threshold for damage. And the employer has to be able to prove that threshold has been met. So this could be very challenging. So for example, if an employee has committed an act of bribery, it can be very hard to dismiss him or her because proving that the act of bribery has resulted in financial damages to the company is often impossible. So that's an obstacle. Aside from dismissal, another ground to dismiss an employee is if they're already being disciplined, either by deferral of wage increase, and they recommit the offense while they're still under the period of disciplinary action, or they recommit the offense after being disciplined by demotion. And this is tricky because they have to recommit the same offense. So let's say an employee commits an act of bribery, and then the next time they do something different. I don't know. So if they don't repeat the exact same type of misconduct, then you can't dismiss them. And the other ground is if the employee takes a total of 5 days off in a month or 20 days off in a year without a proper reason. And it's kind of unusual that they kept the not arriving to work for 5 days in a month as a ground for dismissal, because now it's very simple for the employer to unilaterally terminate the employee for that. But having the total of 20 days off in a year, sometimes employees might be missing, let's say 3 days in a month or 4 days. So that can still be useful. So as I mentioned, if an employee commits an act of misconduct and it meets all these conditions, you can't just push the employee out the door. You have to have a disciplinary hearing process. And it's kind of like a small trial of the employee. So the employer has the obligation to prove the employee's fault. If the employee is a member of the trade union has to participate in the hearing. The employee must be present. They have the right to defend themselves, and they can have a lawyer represent them as well. So it's a kind of like a trial-like procedure. Each party, the employer would present the evidence of the employee's misconduct. The employee would have an opportunity to respond, and the trade union would have an opportunity to respond. Then the minutes of the hearing are all documented verbatim, and every party has to sign the minutes. If one of the parties disagrees with the content in the minutes, then they have to specify whatever content they disagree with and then sign the rest. Another big consideration with dismissal is that very short limitation periods apply. So for most acts of misconduct, it's only possible to discipline the employee 6 months from the occurrence of the act. So not from the discovery of the act, but from its actual occurrence. This period is lengthened to 12 months if it involves the employer's finances, assets, or confidential information. But that's still not very long. And again, this is also from the occurrence of the act. So in practice, this can be very problematic. So if an employee has secretly been stealing money from the employer, and the employer discovers it 13 months after it happened, the employer is just out of luck. The disciplinary hearing and the issuance of the disciplinary decision need to happen within that time frame as well. And it takes some time to organize the disciplinary hearing and do that, I would say at least 2 weeks, probably. So it can be very hard to work with these limitation periods. So some considerations in the context of the pandemic. So the disciplinary hearing notice has to indicate the place of the hearing. So it's not entirely clear whether you're even allowed to do it virtually, which you may wish to do due to the pandemic. The employer also needs proof of service regarding the notice of the disciplinary hearing, and this can be difficult if it's been emailed, for example. Also, presenting evidence at a virtual hearing could be challenging. Maintaining privacy is also a concern. One of the parties to the hearing could have someone else in the room who really shouldn't be there, compromising confidentiality. And then written minutes of the hearing would still need to be circulated, and all parties would have to sign. Okay, so we have another case study. Okay, you have an employee, Mai, who refuses to be vaccinated, but her presence is required at the workplace. According to government orders, employees may only physically attend the workplace if they are vaccinated. Your ILRs, the registered working rules, state that insubordination is a ground for dismissal. Are you permitted to terminate Mai for her refusal to be vaccinated? And the second question, are you permitted to dismiss her for refusing to follow your request to be vaccinated?
Okay, Sarah, and yes, it's a very interesting coincidence that we also have the same question from an attendee, Hong Jan. And the question is that if an employee is required to work outside and she or he refuse vaccination, which is required by the government for company operation, then the employee cannot work at the site. Can the company terminate the employment? Yeah. So it's the same.
Yeah, it's basically
idea,
the same.
yes, because
this issue is coming up in Vietnam, because basically to go anywhere in Vietnam right now, you need to have proof that you've received 2 vaccinations.
Okay, so we have the first answer. No, if the employee is able to work remotely.
Okay, but let's say in this scenario, her presence is physically required. It's impossible to work remotely for this type of job.
Yes, so the working is required on site. So is there any other answers? Yes, and attendees say that yes, in some circumstance. Can you mention or list out which some circumstance? If you don't mind, Miss Bùi Thị Lan.
Oh, what circumstance would she need to physically be present?
Do you want to raise your voice? I think that we can discuss this. Do you want to go further in the circumstance? Yes, another answer, yes. Okay, so.
Okay.
Yes,
should we move along? Yeah, okay. No.
Another one, yes. No. Another one's not permitted. Getting vaccination is the right of everyone. Right. In addition, refusing getting vaccination doesn't belong to cases of dismissal according to the laws. Okay, that's correct. So you are not allowed to unilaterally terminate employees for refusing to be vaccinated, because the employer does not have the right to mandate that. People have the freedom, I guess, to decide whether or not to be vaccinated. Also, you couldn't rely on insubordination in your ILRs because the employer doesn't have the right to demand the employee to be vaccinated in the first place. In a scenario like this, like let's say it's a factory and it's just impossible for this person to work remotely, the employer might be able to suspend her employment basically on the grounds of force majeure. And in this case, she would receive the regional minimum wage for the first 14 working days, and then after that, a negotiated salary, which could be 0. So that would be a safer approach to suspend employment than trying to terminate. If it seems like this will be a really long-term problem, it could even be possible to do a force majeure termination eventually, but at the outset, you wouldn't be allowed to do that. You would have to show you're trying to take measures to accommodate the employee's choice not to be vaccinated reasonably. So suspension would be the more realistic alternative.
And it's also important to determine the reason for the employee's refusal to be vaccinated. Because Vietnam, under the labor code, protected ground of discrimination is disability. So if the employee had some underlying health condition, I think I've heard if people have had tuberculosis in the past, they aren't allowed to be vaccinated or something like that. If it was a medical reason, some along those lines, it could be considered discriminatory to be suspending the employee or taking other disadvantageous measures against them. So it's something to be cautious about.
Okay, so I can see that there is a discussion from Eddie that employer can explore if the employee can be transferred to another role. If no, then it is okay for the employer to terminate by force majeure.
Oh, by force majeure. So you could possibly transfer the employee to another position. The labor code allows for that. In the case of a pandemic, so this could fit that scenario, but you can only do so for 60 days at a time. And the employee receives their same salary for the first 30 days, and then they can have a slight reduction in salary for the second part. So that could possibly be an option. Again, going with the force majeure termination, it's a very untested ground. And since employers don't have the right to mandate employees to be vaccinated, it would be very risky, this type of thing.
Okay, so another question, can employer apply no work, no pay basics for this case?
So in this case, possibly, because one ground of suspension of the labor contract is basically if it's the employee's fault, then you can suspend them with no pay. Normally this would apply like in a strike scenario, but here, again, it would be really important to determine the employee's reason for refusing to be vaccinated. Because if the reason is some underlying health condition, you could not do that. You could not say it's the employee's fault. But if it's the employee's personal preference and now they can't perform their job, then I think you could suspend on the basis of it being the employee's fault with no pay.
Okay, we have another questions from Michelle. So aren't all workers required to be vaccinated in Ho Chi Minh? If so, why can't they be terminated if they refuse to be vaccinated?
Basically, the way the government looks at it is people have a right to their bodily integrity. So you can't force an employee to be terminated. So I think trying to rely on the force majeure termination in this case would be really, really risky. Maybe you could, if you first suspended their employment and tried to explore other options of different positions to transfer them to, then if you could show you exhausted all other possibilities and you still can't accommodate this employee, then maybe you could do a force majeure termination.
Okay. Oh, yes, and another question. So what is the best solution for the company in this case? No vaccination means that she or he cannot work in workplace.
I think the suspension of the labor contract would be the best option. You would have to determine the reason for the refusal to be vaccinated. If it was an underlying health condition, you would have to treat it as like a force majeure type circumstance and pay the employee regional minimum wage for the first 14 working days and then a negotiated salary for the rest. If the employee just had a personal preference, they don't want to be vaccinated, then I think you could say it was the employee's fault and then suspend them without pay.
Okay. Yeah.
Okay.
That's all the question. Thank you.
Okay, moving along. See, our time is getting a little tight. Okay, now let's discuss protected employees. So employers may not dismiss or terminate an employee if the employee is sick, recovering from a labor accident, the employee is being investigated by the authorities, the employee is on annual leave, or if the employee is pregnant, on maternity leave, or caring for a child under 12 months, or on another type of permitted leave. So if you look at the last one about caring for a child under 12 months, A tricky thing about this provision is it also applies to men. So you may have a dismissal case where you're moving ahead with the disciplinary hearing, and then it turns out that the male employee has a young baby, and then you can't proceed. So that can be a tricky provision. So if the time limit for disciplinary action expires, or if there's less than 60 days before the protective circumstances end, you get an additional 60 days, basically to carry out the disciplinary hearing. So part-time trade union officers have special protection. So this answers the earlier question. So if the employer wants to terminate their employee, they have to enter into a written agreement with the executive committee of the trade union. If they can't reach an agreement, the parties send a notice to the provincial labor authority. And then 30 days after the notice is sent, the employer can make a decision and move ahead. But the trade union can request dispute settlement procedures. The other thing to consider is if a member of the trade union executive committee's labor contract is expiring before their end of term, it has to be extended until the end of their term as a trade union officer. So it's very difficult with trade union officers. Have to be careful about that. Okay, we're on another case study. So you have just discovered your employee Lynn has stolen money from the company. After you send the notice for the disciplinary hearing, Lynn informs you that she has just become pregnant. How long must you wait until you can apply disciplinary action?
Okay, so can you have any ideas on how long the discipline action can be applied? Yeah, just make an estimation. Say 12 months. Yes, an answer is that 9 months for pregnant and 12 months after the child born.
That's correct.
Yes,
that
another yes. Another answer. Okay, the same. Also,
okay.
9 months for pregnant and 1 year for taking care of the baby and the 1 year old.
That's correct. So this is not a good situation for the employer. They cannot take any action until 21 months later. It's quite a long time. Once the 21 months is up, then the employer gets 60 additional days to deal with the disciplinary hearing and issue the decision. Can anyone consider another possible approach you could take in this case?
So any suggestion for the employer in this case? If they don't want to wait for 21 months, right?
It's a long time.
So, okay, we have an answer here, the mutual termination.
Exactly. Yeah. So even with protected employees, you can enter into a mutual termination agreement. So that's what you would try to do here. And it would be pretty distasteful circumstances, like when your employee has done something like stolen from you. But sometimes it's your best option.
Yes, another answer is that the employer should wait until the labor contract is expired.
You can, yeah. So there's no obligation to renew a labor contract for protected employees, except for those part-time trade union officers when their term is about to expire. That's like the one case. But otherwise, you could let the contract expire. Yeah.
Yes. Okay, no other answer or questions?
Okay, we'll move on to employee resignations. Okay, so under the new labor code, something they did that is very favorable to employees is they removed the requirement for employees with definite term contracts to have a legal reason to unilaterally terminate their employment. So in the past, if you were an employee with a fixed term contract, you had to have a special legal reason if you wanted to resign before the term of your contract was up. And the one people usually relied upon, it was called personal and family difficulties, but it was actually very specific. And either you had to be moving overseas or caring for a sick family member or dealing with a force majeure circumstance. So it was not simple. But now anyone can resign from their position for any reason, but you simply have to provide notice. So it's the same basic notice periods, that apply to unilateral termination on the employer side most of the time. So 45 days for indefinite term, 30 days for 12 to 3 years, and 3 working days for other contracts. There's a special extended notice period for certain types of jobs. So jobs basically related to the aviation industry, but more relevant to this group would be enterprise managers. So these are the same people who are subject to the 180-day probation period. So this would be like the general director or the chief accountant of the company. These employees, they have to give 120 days notice for an indefinite term contract or a contract of a term of more than 12 months. So that would be most cases, or a term equal to a quarter of the contract if the contract is for a term of less than 12 months. So in most cases, it will be about a 4-month notice period for a general director or chief accountant. There are certain cases where employees can resign without giving any notice. It's basically if the employee is being mistreated. So not being assigned to the correct workplace or working conditions, not being paid correctly, being maltreated or assaulted, being sexually harassed, or if the employee is pregnant and her doctor recommends for the health of the baby to stop working. If a person reaches the statutory retirement age, they don't have to give notice. Or if the employee has received untruthful information during the recruitment stage. Okay, so now we'll move on to employee entitlements. So upon termination, employees are entitled to accrued salary, pay for accrued but unused annual leave days, pro rata amounts for non-discretionary bonuses. In Vietnam, the most common type of non-discretionary bonus is the 13th month bonus. You see that under most labor contracts. And in most cases, it's not dependent on performance or subject to the employer's discretion. So in most cases, employees will get a pro rata amount of that bonus, and severance or job loss allowance, if applicable. And I'll explain more about that in a moment. Termination payments have to be made within 14 working days under most cases, but it's extended to 30 days if it's basically a redundancy termination, or the employer is winding up operations, or one of those force majeure terminations. Employees are almost always entitled to severance, except if the foreigner is deported from Vietnam, the employee is disciplinarily dismissed, the employee is redundant, in this case they get job loss allowance instead, if the employee disappears from work for 5 days, or if they reach statutory retirement age and receive their state pension. And one point that surprises a lot of people is that an employee who legally resigns, meaning they follow the notice period, are entitled to severance. A lot of people are surprised by that because in other jurisdictions that doesn't really apply. So throughout the presentation, I keep saying severance or job loss allowance, if applicable. That's because in a lot of cases, it won't apply. The employee has to have worked at least 12 months prior to termination. And it only applies to working periods not subject to unemployment insurance. So in Vietnam, unemployment insurance was introduced in 2009. So if you have a really long-term employee, their working period before that time would be subject to it. And there's also often gaps in the party's participation in unemployment insurance. The most common type of one is maternity leave. So for the 6 months of maternity leave, usually the parties don't participate in unemployment insurance. So then the employee would get a small amount of severance for that period of time. Foreign employees are not permitted to participate in unemployment insurance. So their entire working period is generally subject to severance or job loss allowance. Severance allowance is equal to half a month's salary per year of service. Job loss allowance is equal to 1 month's salary per year of service, but at least 2 months. And working periods from 1 to 6 months are rounded to half a year, and above 6 months is rounded to a year. When you're calculating this, it's the employee's average salary over the 6 months immediately preceding the termination. So in practice, we see many employers who wish to avoid paying severance allowance to foreign employees, but this can be tricky. So one thing some employers do is they tell the employees that the severance allowance is part of their salary and it's being paid in advance. However, with a recent case, I made a verbal inquiry to the Department of Labor, and they said, no, severance allowance has to be paid at the time of termination. So an employer cannot just say, oh, part of your salary is severance allowance. If an employer is trying to avoid paying severance, one legal way you could do that is to allocate a big portion of the remuneration to something like housing allowance, because severance is based on the base salary in the contract, not on allowances which do not form part of salary. And these are the major ones you could rely on would be like a housing allowance, and this would also apply for a performance bonus. So if you have a large part of the payment to the foreign employee as a housing allowance, that can avoid severance liability. Okay, so moving on to consequences of illegal termination. So both the employee and employer are punished pretty severely for illegal termination. If the employee illegally resigns, and really what that means nowadays is they don't give the proper notice. In that case, they forfeit severance allowance. They also have to pay the employer compensation equal to half a month's salary, and then also compensation equal to the salary for the remaining notice period that was not met. And they have to repay training costs. From the employer side, it's very difficult. So if an employee alleges wrongful termination and they win their case in court, the employer has to take them back. Reinstatement is a mandatory remedy. The employer can negotiate with the employee not to come back, but the employee has the right to come back. It can be very uncomfortable. Employer also has to pay back pay for the period during which the employee could not work. And this would include all the statutory insurance contributions. And they also have to pay at least 2 months' salary as emotional distress. If the employee does not want to come back to work, they get at least an additional 2 months' salary and severance allowance. But in practice, employees will negotiate a really high amount not to come back because they have the power in that situation. So just from a practical point of view, labor lawsuits often take 1 to 2 years to complete. So there's significant legal costs involved, and illegal termination can be very damaging to an employer's reputation. In Vietnam, there's labor newspapers that publish stories, sad stories about people's wrongful terminations. From the employee side, if they're bringing a wrongful termination lawsuit, they don't face very big consequences if they lose. They don't have to pay any court fees, and lawyers usually work on a contingency basis for employees. So that's probably why there's a lot of labor claims in Vietnam. Okay, now we can go to Q&A.
Okay, thank you, Sarah, for your clear and informative presentation. And now we will move on to the Q&A questions sections. And dear attendees, during the Q&A session, we are still, please feel free to continuing sending your questions via Q&A box so that we can address all of your questions. And I had here a long list of questions, Sarah. Please prepare yourself, okay? So I will go through one by one. Okay, so the first one, regarding probation period, you confirm that all managers can have a 180 days probation, even if the chief accountant does not manage anyone. Is there any specific criteria?
Yeah, I should explain this. So it's a manager as defined under the enterprise law. And so that's a very restrictive definition. So it wouldn't mean just like a normal manager in a company. Under the enterprise law, defines these managers as like the general director, deputy general director, or managers who are specified in the company's charter. So the charter is like the incorporating articles of the company in Vietnam. And most company charters will identify the chief accountant as a manager. So that would be why. So it's not just like any type of manager. It's only these very specific positions.
Thank you. And the next question. So what are the consequences if we do not have democracy in the workplace regulations? Do the authority clamp down on this?
Okay, so you could face an administrative fine. The other concern is for a long time, basically the labor inspectorate, they were kind of ignoring this issue and it wasn't really a big deal. But in the last few years, we've seen them pay more attention to it. So if you have a labor audit, you could face problems if you don't have democracy in the workplace regulations.
Okay.
And then when you have these scenarios where you're supposed to do the dialogue sessions, if you don't have the democracy in the workplace regulations, be very messy to sort out.
Okay, so the next question, what happens in the following scenario? We hire an employee on an urgent basis and that employee starts work. After the result of the background checks on that employee come back and the employee failed the checks for some reasons, can the company unilaterally terminate the employee?
Okay, so if it's within the probation period, yes, definitely. You don't need any notice or reason. If it's after the probation period, it would depend. So if you ask the employee during the recruitment process, whether, I guess it depends what the background check is on, but I'm guessing like a criminal record or something. So if you ask them during the recruitment process and have this in writing, whether they have a criminal record and they said no, and then later you discover they do have one, then you could terminate them on the basis of providing untruthful information.
Okay, so do we need employees representative in the dialogue for mutual termination with the employee?
Oh, there's no dialogue process for mutual termination, and there's no necessity to include the trade union at all. Normally, it's just a conversation directly between the employer and the employee. So that's another reason why the mutual termination option is the best. It's very simple.
Okay, another question. Can the employee file a complaint after mutual agree to terminate and sign that he is forced to agree?
They can always try, but in practice, mutual termination agreements are pretty tight in Vietnam. The employee would have to have some very strong evidence that their consent was not genuine. So in practice, we rarely see mutual termination agreements challenged. So it's a fairly safe option in Vietnam.
Okay, the next one. Is the purpose of the corporate dialogue to vote on whether to terminate the employment of the non-performing employee?
So it's not voting on it. They're just permitted to, I suppose, be consulted upon it, but the employer is not bound to follow any recommendations or opinions.
Okay, and please advise the effective way to prepare the evidence to prove the employees had absent for 5 consecutive days without permission to be unilateral termination.
So to show evidence of that, if all the employees are coming into the office, it depends, I guess, how you monitor your employees. If you could show, if your employees swipe in with a card or something like that, then it's very simple. You can show they're not attending. Or you could take like a witness statement from the HR managers. It's been 5 consecutive days and the employee has not come to the premises. On the other hand, if everyone is working remotely from home, or if that's an option that employees are permitted to do, then it's very challenging. Then you have to show the person is unreachable by phone, they're not replying to emails. It can be very hard in that case.
Okay, and can the participants sign the minutes on different days and different from the hearing date?
Yes.
Okay. And okay, and other questions that relate to the case study of TBO. In this case, Ms. Jensen Nguyen has a question like this. Can we apply policy clause 1, article 36 to terminate the employee? So
which article?
Yes, Ms. Jensen, do you do you have the text with you? You can cite this full article for us so that we can, the policy clause 1, article 36.
36.1E or something? Is that being absent from work 5 days or more?
Yes, I can cite here if Ms. Jensen not there. It's about in the event of a natural disaster, fire, major epidemic. Yeah.
Oh, like a force majeure termination for TBO? Possibly, yeah. So if the employer could show they had tried every reasonable type of means to help him re-enter the country and it wasn't possible, then I think they could rely on that ground of termination.
Okay, and other questions? Yeah, what will happen if the employee does not submit resignation in advance as stipulated by the labor court?
So then they're subject to those penalties I was talking about. So they would forfeit severance. They would also have to pay the employer half a month's salary. And then they also have to pay an amount of salary equivalent to the days not notified. And repay training costs as well. So it's not good.
Okay, and back to the case study relating to the vaccination. So if someone is not vaccinated due to personal, not medical reasons, and there is mandatory vaccination in Ho Chi Minh, surely they can be terminated?
Everyone wants to terminate. So as I said, I think it would be very risky to try to rely on force majeure termination immediately for that. I think it would make more sense to suspend the employee. If it's due to personal preference, you could say it's the employee's fault and suspend them without pay. And then if the person would not change their point of view and the order remained in place, maybe after a period of time, you could terminate them due to force majeure.
Okay, another questions about the probation times and no contribution to the unemployment insurance. Do we pay the severance allowance?
Sorry, can you say that again?
Yes, so how about the probation time not contribute to unemployment insurance? Do we pay the severance allowance? The question may be whether the severance allowance cover the probation time. Yeah.
So probation had been removed as one of those periods for severance allowance, but I believe probation was added back in. So I think if you're not participating in statutory insurance, you do have to pay severance for the probation period under the new labor code. And this is just new because there had been a decree that said the probation period is not included for the working time, but under the new labor code, you do. So this is also a reason why it's preferable to have the probation period in the labor contract itself, because if that's the case, you'll be paying all the statutory insurance. But if you have a separate probation agreement, then you would not necessarily be paying statutory insurance. And then that typically it's a 60-day period. That 2-month period would be subject to severance, would be rounded up to half a year.
Okay, and another question, is it necessary to use on unspent annual leave each year, or can it be carried over? Is that okay from tax perspective?
From a tax, I don't know about the tax perspective. In Vietnam, it's not entirely clear whether employers can say that unused annual leave is forfeited at the end of the year. But in practice, a lot of companies do stipulate that. But in the case of termination, whatever annual leave is accrued for that year has to be paid out.
Yes, and so what is the effective way to dismiss an employee that receive or give bribe?
Yeah, it's very challenging because that is not one of the listed grounds of dismissal in the labor code. So you have to prove the company has suffered financial damages. So honestly, from a practical perspective, you probably can't dismiss the employee. In fact, making the bribe could financially benefit the company. So what you might have to do is basically sit down with the employee and say, this is a criminal offense. It is an offense under the penal code. So you could report the employee to the police, and then if they were found guilty and imprisoned, then you can terminate the contract. But you could say to the employee, sign this mutual termination agreement and leave, or this is the other option.
Okay, and it should be the last question then. An employee confirmed resignation plan by email and her manager approved by email also. But after that, the employee said that she was not submit resignation letter officially, had copy with confirmed.
So the employee.
We confirmed last working day, and now she wants to continue working. Can company reject this request and consider resignation by email is official?
Yes, yes. So there's no stipulated form for the notice of resignation. So if she sent her notice and the company accepted it, then she is not entitled to withdraw her resignation.
Okay, and yeah, and another one had just popped in. So in practice, it's hard to obtain the employee's agreement for mutual termination, and they sometimes ask for unreasonable benefits, such as 6 months salaries. How much of an additional benefit would be considered a reasonable, acceptable benefits in general that some companies often give the employees?
So it depends. It depends basically on the strength of the employer's legal position to terminate the employee through some other means. So for example, if you have like a clear case, if you have strong evidence for your redundancy and a strong legal basis, but the employee is trying to dispute it, then you may not offer a very high settlement package because you can just go with the alternative of going through with the redundancy. But if the employer has a weak legal basis, so a lot of cases, some employers don't have ILRs, internal labor regulations, and the employee has committed an act of misconduct. So in that case, the employer does not have a lot of options. Or with the poor performance, if you don't have a performance policy in place, that can also be a problem. So typically, I would say negotiations usually begin around 2 months, and then they vary depending on what alternatives the employer has. But it's not uncommon to see it go up pretty high.
Yes, thank you, Sarah. And it's about the last question. Is there anyone else? Do you have any other questions for Ms. Sarah? Okay, so thank you very much, Sarah. And so do you have any final advice or thoughts for our attendees before we close?
Just one final comment, because now through the presentation, you see it's very complicated to terminate employees in Vietnam. So I would suggest when you first hire a new employee to offer them like a 1 or 2 year contract. It's a very risky idea to offer someone a permanent contract from the outset, because as you can see, a lot of problems can come up, and it's always a very complicated procedure, even if you have all your policies in place. So as a safety measure, you can have people on 1 year contracts, and if it's not working out, you can just let the contract expire.
Okay, again, thank you very much, Sarah. Thank you and see you.
Okay, thank you. Bye-bye.